appeal in the matter of Blake and another and Fox and another.
Mr. Green.
May it please your lordships and ladyship. I appear with Miss Malzek, who sits to my left, and Mr. Callis, who sits immediately behind me.
Thank you.
On behalf of the appellant, and my learned friend Ms. Page, King's Counsel, appears with Mr. Busuttil, who sits just there, and Ms. Grossman.
Thank you very much. We've got a day and a half. I imagine you've agreed.
We've discussed. I'm going to go till 3, my learned friend till 12:30 tomorrow, and then half an hour for reply.
Excellent. Thank you very much.
My lords, my lady, I prepared this last night for myself and thought it might be helpful for the court. It's a one-sheet guide to where everything is.
Thank you.
It's double-sided, and on the one side it's got a sort of map of the liability judgment, which is the crucial one for most of the grounds, and the other side it's got a map of the bundles. And I hope the court will forgive certainly me and possibly my learned friend if we're mainly working from the original SUP bundles rather than the key.
As long as we've got both the electronic references. So when you give a page number, if you can give it for hard for some of us and electronic for others, that would be great.
I'm most grateful.
Thank you.
My lords, my lady, this appeal obviously spans quite a large scope factually, and I just want to get out of the way the fact that we are very conscious that all the appellate authorities show very clearly the appropriate approach of this court to findings of fact and evaluative assessments made by the trial judge with the advantages that the trial judge enjoys. And I'm not trying to trespass anywhere near any of that for reasons which it will take me a little bit of time to explain, but I hope I'll be able to explain clearly. And the appellant submits that the learned judge erred in law, in her approach, in failing to make findings on disputed facts, failing to identify agreed facts, which were plainly relevant, for example, scale of publication of the tweets themselves, which is entirely glossed over. And in doing that, failed to do what the learned judge herself referred to as the inferential groundwork before proceeding to draw the inferences that she did, particularly as to serious harm. It is unusual, in my respectful submission, where there is evidence on important or disputed issues of fact for the learned judge not to confront that and make a decision as to how those disputes are resolved, or what she makes of those facts where their characterisation is properly in issue and going to the issues to be decided. Against that background, I hope the court will forgive me just to clarify, first of all, what actually happened, because without a clear understanding of that, it isn't that easy to get a handle on some of the issues raised in the appeal. And can I ask the court to look at the first supplemental bundle at page 2, which is the index, which I think we have my learned friend Mr. Callis in part to thank for the precision of the timings included in the index, because it's extremely helpful. If one can look on page 2, I don't know if my lady has page 2, which is the index to SUP 1. The key events start at item 20. And at item 20, we see the tweets by Sainsbury's. They're on the 1st of October. And I'll show the court in a second how it works, but you need to read 178 with 188 the document at number 23 because Ben Bradley tweeted the underlying tweet that Mr. Fox was referring to when he said, "See further here." I'll show the court that in a minute, just to know that 178 needs to be read with 188. There's an email from Mr. Fox's agent, Sue Latimer, on the 2nd of October, offering him work. The court will anticipate we say that doesn't fit terribly well with the learned judge's analysis, that she'd given up on him already by that stage. Then 23 is the Ben Bradley tweet, which I'll show the court in a second. And that's on the 2nd of October, late at night, 20 to 11. And then 24 is Mr. Fox's so-called boycott tweet, which is his Sainsbury's tweet that he makes on the 4th of October at 10:45. And then 25, 26 and 27, you can see, are the 3 tweets accusing Mr. Fox of being a racist and which he sued upon below and on which he appeals here. And just a quick point of detail there, C3s comes first in time. So Nicola Thorpe's tweet, which is the one that the Court of Appeal previously decided was obvious mimicry, her response was obvious mimicry. Mr. Fox's response to that tweet was obvious mimicry. C3's tweet that starts that with Mr. Fox is at 4:45. Mr. Blake's tweet then follows at 5:11. And then Mr. Seymour's tweet at 5:19. And then at item 28, you can see Mr. Fox's tweet to Mr. Blake is at 5:29. And just a very tiny point, in the chronology the court's been provided with in the appeal bundle, there is a typographical error saying that tweet is 5:20. It's 5:29. And then over the page...
5:29 or 5:19?
So number 28,
Yeah,
which is Mr. Fox's tweet
yeah,
responding to Mr. Blake.
yeah.
That's one of the 3 paedophile tweets. Is at 5:29, and that's the correct time in the index.
I'm getting a bit lost on... Oh, I see. Sorry, I found it now. Good.
That's great.
It's just, there's 1942 at the top of the page, which is apt to confuse as to timing, but I'm looking underneath. Is that right?
Yes, item 28
Item 28.
at the foot of page 2 of the index.
Well, I'm looking at this electronically, so pages of indexes don't really...
Oh, I'm so sorry. It's the first...
I'm on page 193 of the bundle, yeah? You were asking me to look at Laurence Fox's response to Mr. Blake.
My lord, you're looking at the actual document itself?
Yeah.
I was going to take the court briefly through those in a second, if I may.
Right.
I just want to get the tight chronology of about 10 items very clear before we start, if I may.
Very well, okay, thanks.
I'll come back to that. So 1729, the first one, and then item 29 is at 1730, and then at 1732 you get Mr. Blake tweeting his "Here we go" tweet, about which I will be addressing the court in some detail. So 3 minutes after Mr. Fox tweets about Mr. Blake at 5:29, Mr. Blake himself tweets his "Here we go" tweet, which we'll look at in a second. And then he then tweets, "Is this a standard retort?" 5:37, and then you get Mr. Fox's tweet about Nicola Thorpe, which is at 5:51. And
Sorry to interrupt. I don't mind at all whether you use 551 or 1751.
I'm so sorry.
But you're
I'm
chopping
in
between the two.
I apologise.
It's very difficult to take a name.
I'm so sorry. It's completely my fault.
No, don't worry.
1751.
Just choose whichever you want.
1751.
But stick with it.
Yeah.
Thank you.
1751.
Thank you. Sorry, and 1751, what happens then?
That's item 32. That's Mr. Fox's tweet to Nicola Thorpe.
Thank you.
And then there are a series of other tweets that follow between the parties, including item 36, which is Mr. Fox's language is powerful tweet, which he does at 18:24, which is within under an hour from his original first engagement. So, can I actually take the court to those, if I may, just to explain the chronology in a little bit more detail. If we start at bundle S1, page 178, it's tab 20 if the court has tabs. So what happened was Sainsbury's supermarket on page 178 tweet, "We are celebrating Black History Month this October. For more information, visit Sainsbury's Black History Month." And if we go to page 188, so we can see that's 10:11 on the 1st of October. We go to page 188. This is Ben Bradley MP tweeting what Sainsbury's had tweeted in relation to that. And you'll see it says, "What have we been doing to support our colleagues? We've relaunched our network, etc." And then second paragraph, we've provided our black colleagues with a safe space to gather in response to the Black Lives Matter movement. And it was that to which Mr. Fox took objection. So Ben Bradley's tweet is on the 2nd of October, 2 days before Mr. Fox has said anything. We go to the next page, page 189. Mr. Fox tweets, "Dear at Sainsbury's, I won't be shopping in your supermarket ever again while you promote racial segregation and discrimination." And pausing there, my lords, my lady, the court may have noted that the relevant section of the Equality Act, which identifies segregation as automatically being less favourable treatment for the purpose of racial discrimination, is in the bundle at tab 47. Bundle authorities at tab 46.
Do you want us to look at that now?
No, but I'm just mentioning that the Equality Act itself does say that. I'll make a short submission on it later.
And which section?
That's section 13, and the key subsection is 13.5.
Thank you very much.
And it reads, "If the protected characteristic is race, less favourable treatment includes segregating B from others." So Mr. Fox's tweet is on it's a general policy issue to all the world. not addressed to any individual, certainly not addressed to any of the three claimants, none of whom, as far as we know, had anything material to do with Sainsbury's. And he says, I sincerely hope others join me. RT for retweet, hashtag boycott Sainsbury's. And then he says, further reading here, with a little finger pointing down and a link. And the Sainsbury's web app link in blue, immediately below the little hand pointing down, takes you to page 188 that I've just shown the court, the immediately previous page. So, a fair reading of what Mr. Fox was saying was he was criticising racial segregation expressly and discrimination. And he made a specific reference, further reading here, with an emoji pointing to the link, and the link took you to the post which said Sainsbury's were creating a safe space for their black employees to gather. So that's what Mr. Fox did, and that was really understood in three different ways. Firstly, it was understood by Mr. Fox in the way that he intended it. And that is also how Ben Bradley MP had understood it when he had tweeted, as he did on page 188. It was understood differently by the claimants because it only emerged in cross-examination at the trial before the judge that none of the claimants had clicked on the link. So whatever view the court takes of what they decided to do and how they decided to respond to Mr. Fox, it was done without bothering to click on the link which was supposed to identify the basis of what he was saying. And it's clear that they described, for example, Nicola Thorpe described him as calling for a boycott for a supermarket because they've released a statement in support of black employees, customers and black history. What else do you call it but racism? So it's plain that their understanding of what he was saying was materially different from what he had intended. And then if I could take the court to the learned judge's judgment at paragraph 117,
Liability judgment.
Liability judgment, which is core bundle page 137, tab 9 for those in hard copy. The learned judge says, Mr. Fox called Sainsbury's racist, promoting racial segregation and discrimination on account of its safe spaces policy. And that is correct, and that is taking into account the link. A substantial body of opinion at the time that thought that having an online forum where employees of colour could discuss their reactions to the issues of the day, institutional racism, BLM and so on, without being overheard or judged by their employers, whose views they might after all be minded to include in that potentially critical discussion, was positively anti-racist. Now there are two immediate problems with that summary. First, there was absolutely no evidence of a substantial body of opinion at the time before the court. Secondly,
So what? No evidence at all.
no evidence of a substantial body of opinion to that effect.
Was it
Indeed, there were tweets in the bundle
Yeah.
in responding, which I can easily show the court. They're quite striking. where people are heavily siding with Mr. Fox, for example.
Well, we've read some of those, but you say there were none or not many?
Well, there wasn't a substantial body of opinion, which was a proper foundation for the judge to reach a position, a view of society. And the other point about it, my lord, is that it was not clear that it was an online forum at all. Sainsbury's later clarified afterwards that it was an online forum. But it was not clear, and that was a subject matter on which Miss Thorpe actually sought confirmation from Sainsbury's at the time, didn't get it straight away. The other problem with that is actually what Sainsbury's were doing were not, what's implied by the learned judge saying that by having only black employees gather, they would not be overheard or judged by their employers. It was not a horizontal management and employees divide that was being proposed by Sainsbury's with any implicit assumptions about who is in which of those groups. That was not what Sainsbury's were saying they were doing. They said it was for all of their black employees. So that would mean that a black employee whose best friend was white couldn't get their best friend to come with them to the group to discuss those issues for support. And that's what Mr. Fox took objection to. Returning to the limited understanding of the claimants then, we go forward one page back in bundle SUP 1 to page 190. And this is Ms. Thorpe's tweet, 1645, as we can see on page 190. And the terms in which she begins this exchange with Mr. Fox, we say, are striking and important. What she says is, having not bothered to click on the link, any company giving future employment to Laurence Fox or providing him with a platform does so with the complete knowledge that he is unequivocally, publicly, and undeniably a racist. And they should probably reread their own statements of solidarity with the black community. And that's been held to be a statement of opinion. And the fact that it was a matter of opinion, I'll come to in my submissions in due course, but weighed apparently heavily with the learned judge in that an expression of opinion has much less propensity to do serious harm. We don't accept that's right. We accept that actually what the Defamation Act itself contemplates in section 1 is for the court to answer the question, the statutory question formulated in section 1, which is, did the publication of the statement cause serious harm? And one can quite see that there may be some opinions which cause less harm than some facts which are alleged. But the question is, looking at the statement as expressed, did it have a propensity to cause serious harm? If and insofar it's necessary to channel that into the exercise of drawing an inference, which we accept is perfectly permissible. We say that is in uncompromising and extremely aggressive language, effectively calling for the cancellation of a man with dependent children. Any company giving future employment to Laurence Fox or providing with a platform does so with a complete knowledge, is unequivocally, publicly and undeniably racist. And they say there, that is expressed in terms which are as close to being a statement of fact as an opinion can be, in our respectful submission. The uncompromising language of complete knowledge, unequivocally, publicly, and undeniably, in combination, show that there is no material difference between that being alleged as a fact or stated in that way as an opinion in terms of its likely impact. It's also important for the court to have in mind that at the time Ms. Thorpe tweeted that, true it is that she had previously been an actor in Coronation Street, but at the time she was still presenting television shows. From April 2022, she was co-presenter of The Talk on Talk TV 4 nights a week, debating current topics. She was also a regular guest on the Jeremy Vine Channel 5 show, Jeremy Kyle Talk TV, and Piers Morgan Uncensored on Talk TV. All 3 shows are live transmissions debating topical issues of the day. So she was both a celebrity and a former actor. Then at page 191 of bundle S1, this is over the page, we have Mr. Blake, the first claimant's tweet. And he says, what a mess, what a racist twat. Again, he'd not bothered to look at the link, and he expressed himself in unnecessarily unpleasant language in a personal attack on Mr. Fox. That mattered, parenthetically, my lords and my lady, because what we actually saw happen was a number of people tweeted that tweet and tagged Mental Health First Aid England, for whom Mr. Blake worked in an extremely serious position. And it was Mr. Blake's evidence as to serious harm. He said, I'd contacted my employer, MHFA England, about the tweets and the situation, as I wanted to make sure my chair was aware of what had happened. So this was part of his serious harm case, that he'd had to do that. Now, just so the court knows, we identified tweets that tagged both MHFA and Lord Patel and drew the tweet to their attention. We also identified the fact that the people who were tweeting those tweets were calling into question Mr. Blake as CEO of Mental Health First Aid England. Mr. Blake's approach, one of them said, and this is, I'll just give you the reference, I don't want to take the court to it, but it's in S2 at page 172.
And what is this going to?
This is just giving context to Mr. Blake's serious harm case and giving context to how his language, when he says what a racist twat, was understood. Because there's a tweet saying, MHFA England, do you agree with your CEO's public comment about a person who's publicly known to have only recently been and may well be suffering from mental health issues? If so, doesn't this undermine MHFA's mission? And you can imagine Mr. Blake was cross-examined about that. And a further person said, as a qualified MHFA, we're always told to listen to people and not judge. Maybe as CEO, you should practice what you preach, and you should please explain what was said in the tweet that was racist. A response would be great, thank you. So we know this independently came to MHFA's attention, not only through Mr. Blake. And what emerged was that the letter which we had to apply for disclosure shortly before trial from Mr. Justice Nicklin, we had 2 disclosure hearings shortly before trial to try and get some, but not all, disclosure. The letter emerged, and the letter was entirely about his breach of their online policy in having used the word twat, because it was unacceptable. It did not mention the paedophile allegation anywhere, and the letter simply said, as he'd shown such strong white allyship, they thought overall it was fine, and they'd take no more action. So credentials burnished by showing strong white allyship, not reputation harmed by Mr. Fox's response. And that was one of the limited number of pleaded, I can take the court to pleadings in a minute, complaints, specific complaints of serious harm. So that's page 191. Then 192, and parenthetically, my lord, that's a very good example of something that we put a lot of effort into. We cross-examined on, we got disclosure on it because it was relevant. Mr. Justice Nicklin would not have ordered disclosure if it wasn't. And we fought it at trial. We cross-examined on it. We won on the cross-examination, if I can say so in the advocate sense. You got what you wanted. And there's not a mention of that in the judgment. It's all skated over.
And you say it was relevant to the issue of serious harm?
It was. I mean, the bottom line, my lord, is the overwhelming impression is that the reputations of all 3 claimants were burnished by their encounter by Mr. Fox at the assessment date. Whatever the position on the night, which was probably jolly upsetting, there are some trolls on Twitter, we know that, but by the date of assessment, which the judge doesn't identify, but it's got to be either, my Lord Justice Warby's expressed an opinion on this, but it's either the claim form date or the trial date.
Very tentative.
Well, I'm being even more tentative, my lord. I would just respectfully say there are a number of features of this judgment which are very unusual. In other areas of the law, and I realise I'm a slight trespasser in this area, but I don't understand the approach to basic evidential tasks of the court to be any different than elsewhere. In other areas of the law, you identify the date of assessment, you identify what you knew as at that date, you identify what was likely thereafter, if that's a statutory test, which it is here, you make findings on all the important primary facts, and against that, you decide whether those 5 primary facts, together with any other matter such as the inherent gravity, testing against what in fact happened, justify an inference. You do not do a bit of an overview of the facts with a general preference for various bits of evidence without actually engaging with them, and then say, well, from the single meaning, I'm going to infer serious harm, which is what happened on the Claimants case, we say. That is effectively what happened. I accept it's not literally set out like that, but it is so close as to make a conflation which the Supreme Court in La Chaux in paragraph 20 said you don't make. Of course you can use it, that's common sense. The gravity of the allegation. It's common sense that a more serious allegation is more likely to cause harm. That's a matter of logic, not law really. But that you don't normally draw inferences without making the primary facts, which might bear on whether you draw them or not, and if so, what inference to draw. So we're on that. That was Mr. Blake. If we go over the page to page 192, we've got Mr. Seymour, and he says, imagine being this proud of being a racist, so cringe, total snowflake behaviour. Again, an unnecessary personal attack, without having bothered to read what Mr. Fox was referring to. And then 193, we can see is at 1729, and Mr. Fox says, pretty rich coming from a paedophile. Sorry, I'm so sorry. Yeah, Mr. Fox says pretty rich coming from a paedophile, and this is a response. I'm so sorry. The screenshot, I apologise, this is at 1942. The screenshot is at 1942. Yes. Oh, I'm so sorry.
Sorry, we're on page 192.
We're on page 193.
Right, yeah.
This is where we were before.
This is where we were.
Where I was. Yeah. Everyone else was somewhere else.
My learned juniors were helpfully giving me an answer to your lordship's question.
Yes.
I thought they were correcting me having made a mistake.
No, fine.
So what I told the court is correct. The time of the tweet is 1729.
Yeah.
My Lord Justice Warby asked earlier, having galloped ahead, quite understandably, what 1942 was. That's just the time at which that screenshot was taken.
Yeah. So on page 192, we don't actually have the time of Mr. Seymour's tweet, but we get that from the index.
Yes, we do. We've got it elsewhere as well.
Yeah.
Yeah. Oh, Mr. Seymour's tweet. Yeah, no, we're talking about 1-4. Mr. Seymour's we get from elsewhere, but the time is correct. Going forward, 194. Mr. Fox responds, says the paedophile. And then 195 is the here we go tweet. So one of the things that the claimants claimed was that they'd been distressed at the time, and Mr. Blake was challenged based on the fact that what he tweets immediately is, here we go. And they were also taken to some of their internal messages between each other. But the other thing that Mr. Blake also did was this is at 3 minutes, this is at 1732. You can see bottom left corner.
What, on 195?
On 195. It says 532, but I'm converting it to 1732.
Thank you.
So as not to get in trouble. But you can see it's just literally 3 minutes after Mr. Fox's tweet.
Yeah.
And what we know is that only about an hour later, if I could just ask the court to look forward to page 208. Mr. Blake tweets, meanwhile at my gaff. and that's showing, indicating where he is. We contended that he was not fearful for his safety, and indeed, 4 days later, on the 8th of October, he tweeted confirming that this was Trebarwith Strand, because I can give the court, I'm not going to take the court to the page, but it's S2, page 248. There is a tweet from Hannah, Hallam sports officer, in response to that photograph, which says, Trebarwith Strand looking mighty fine. I'm extremely jealous that you call this place home some of the time. And he says, it's where I grew up and 100% where my heart is. So by the 8th, he is identifying where he is.
Can you just give me the reference to the meanwhile at my gaff?
Sorry, yes, it's S1 204.
Thank you.
208.
Sorry, 208.
I think it's 248, isn't it?
No, it's 208.
208.
208.
248 is in bundle 2,
Yeah.
208.
identifying it as Trebarwith Strand.
Yeah. It's tab 37 for those with. So I'm just giving the court some examples of some of the factual challenges which find absolutely no recognition or acknowledgement even in the learned judge's judgment. Then if we go forward on page 196, back in bundle S1, what a mess, that one, Mr. Blake retweets. You can see this post is unavailable. Does the court see that?
Yeah.
The reason for that, parenthetically, my lords, is that by 9:35 a.m. the next morning, Mr. Fox had done two things. He'd deleted the tweets, his tweets, which Mr. Blake had asked him to do, and he did. And when he deleted them, he posted a tweet himself identifying the allegations as baseless. And I'll show the court that. So by 9:35 the next morning, not only do you have the three tweets being treated largely together, with Nicola Thorpe's one, on which the court's already made its findings of mimicry, but you also have the fact that Mr. Fox has deleted them and referred to them as baseless. So that's why it says this post is unavailable. But Mr. Blake tweets there, at Laurence Fox, just checking whether you're mixing me up with someone else or if this is just a standard retort.
So that's 1737.
That is 1737, my lord. And then 197, the tweet where Mr. Fox quote tweets Nicola Thorpe, and I'm sure the court understands the difference between a quote tweet and a tweet which attaches a photograph of another tweet. But he quote tweets Nicola Thorpe and he mocks her, what she said about him, simply by changing his name to Nicola Thorpe and changing the word racist to the word paedophile. And that's the tweet, that's the tweet her claim is struck out, because that tweet was found by the Court of Appeal to have been obvious mimicry and therefore not defamatory. And that's one of the key points on the single meaning, which the judge adopted as the driving determinant of whether serious harm had been occasioned. The single meaning doesn't take into account all of the other context, which in this particular case we say is acute and is unusually acute. My lords, my lady, the reason I say that is this. Normally, so Munro and Hopkins, for example, there was no doubt someone had done something bad. The question was who it was. Normally, the single meaning will be a very close proxy for how it's likely to have been understood. But in the present case, Mr. Fox's intended meaning was a denial that he was a racist. And his suggestion only works rhetorically if he's accepting that they are not paedophiles. It doesn't work the other way around. He's not saying, when he immediately tweets the next morning, they're baseless, and then repeat, I'll take the court to where he said this at the right moment of the chronology, but when he repeatedly says to the press, for example, Julia Hartley-Brewer in an interview, if the game is to throw away baseless allegations, two can play that game, is the gist of what he says. When he's saying that, he's not saying, I am a racist and they are paedophiles, and everyone understood it in that way. So this is an unusual case where the question of whether or not the single meaning is remotely a reliable guide to the likely harm is acutely an issue. And that distinguishes it from, as I understand it, from my learned friends, Miss Marzek and Mr. Callis, who know more about this area than me, from many, many, many cases that come before the courts under the provisions of the Defamation Act. So if we go forward to page 198, the court can see there, bottom hole punch or fourth one down, depending on whether one's electronic or hard copy. Nicola Thorpe says he's calling for a boycott of a supermarket because they've released a statement in support of black employees, customers and black history. What else do you call it but racism? And they had to sort of fine-tune their pleading in relation to honest opinion, effectively to a sort of donut of you're not sufficiently on board with other people's anti-racist strategies, and therefore it's that sort of racism, not the normal sort. Then there are some further tweets. I won't take the court to all of them, but if we look at 205, this is still, this is 1807 on the evening of the 4th of October. And this is C2, Mr. Seymour, whose performance name is Crystal.
Sorry, which page again are we now?
205.
Thank you.
Now adding homophobic, boring and lazy to your list of adjectives. What a sad little life, Jane. And then 206 is 1824, the same night. Language is powerful. To accuse someone of racism without any evidence whatsoever to back up that accusation is a deep slander. It carries the same stigma and reputation-destroying harm as accusing someone of paedophilia. Here endeth the lesson. So he's making pretty clear that it's a rhetorical retort on the basis that he is not a racist, and he's applied the same brush to them. See how you like it. 207, we can see that by 6:58, although we haven't got the exact time, still on the same night, same evening. We can 6:58. We can see the screenshot at the top, and you can see language is powerful. And so I think it's actually the next day, this screenshot. Anyway,
If it's 06:58, it must be.
I think it's the next day. Yeah, it's the next morning. But I think it seems that it's 6:58 in the morning, but it's referring back to tweets 12 hours ago. So
This is just on Mr. Fox's account. It's not
yes.
using other people's names. It's just this is only going to people who are following him.
It is. Your Lordship's completely right. And he says as soon as he apologises for calling me a racist, then, oh yeah, otherwise it's free range on misuse of language. But, yeah, it's right for the court to know. On the analytics that we had before the learned judge, which were, some of which were identified as analytics and some were inferred where the tweets have been deleted. The estimate, which was not disputed, was that Language is Powerful got 1.1 million impressions, which is huge. And the original estimate for Mr. Fox's paedophile tweets were between about 160,000 and about 240,000. Mr. Callis, the Twitter expert, tells me that, my lord, although it was true it only goes to Dee's followers when Munro and Hopkins was heard, that had changed by this date.
Right.
So it can be promoted to anyone. And there was an agreed... So we'd taken the trouble to do two things. We served a hearsay notice about how the algorithm worked and had changed, which I'd forgotten in that moment, when your Lordship asked me. That's in the bundle if we need to look at it. And then from that, there'd been an agreed statement of facts and matters about how it worked, which recognised that change.
Right. I mean, one of the things that may be or may not be of significance in this case is overlap.
Of course.
And I hadn't really got my head around where you are on that. So
I'll definitely, I promise I'll come to it. And some of it's uncertain, but we say actually the volume of material is very striking. Because, for example, Mr. Blake's own republication, if we go back to the Here We Go tweet, Mr. Blake's own republication, which we find at page 195, the important thing about that was that Mr. Blake chose not to quote tweet, but to take a screenshot of what Mr. Fox had said. And the point about that was that ensured that when Mr. Fox did what Mr. Blake asked him to do, which was to delete his tweets, Mr. Blake's Here We Go tweet that he did 3 minutes later was not deleted. And that takes, you have to make an effort to do that. Because if you just want to reply, that's one click. But if you want to take a screenshot and add that, that's actual work, which Mr. Blake had undertaken within 3 minutes of Mr. Fox's original tweet about him. And my lords, my lady, that was still up at the date of the remedies hearing. And not only that, it had 594,000 impressions and quite high levels of engagement, dwarfing by about nearly threefold, certainly more than twofold, what Mr. Fox had said about Mr. Blake. And again, this is something into which, when I take your lordships to the annex, and obviously we did the hearsay notice to get how it works, and then we did the analytics, and then actually huge work by my learned junior, Mr. Callas, did an excellent annex trying to identify what could properly and fairly be inferred. I think he might have been accused of being an expert, but I think his answer was the Regius Professor of Adding Up wasn't available. So he offered his services to do it. And that annex, I will show the court in a minute, to answer my Lord Justice Warby's point about overlap and an overall scale of publication. But there are 2 points on this. One, we said we should have won because of all of that. And 2, the learned judge didn't even deal with it anywhere. And given that there are 2 sections on extent of publication in the learned judge's judgment, it is surprising that the available evidence on extent of publication was not addressed. And we go further, the judge actually rendered a characterisation of what had happened, which also did not fit with the evidence. There's been on a sprint room or Harbour Aziz analysis of whether there's an adequate treatment of the issues. I mean, with the greatest respect to the learned judge, you can't completely ignore the "here we go" tweet, particularly when I explained to the court the history of it, which I'm going to come to, because it was a huge circulation and it was pleaded as a confounding tweet. There's a pleaded issue about it, and you can't ignore the extent of publication. And you also can't ignore the extent of publication of all the other tweets, for the very reason that my Lord Justice Warby just asked me that question. It's plainly relevant. And with the greatest respect to the learned judge, he just doesn't even go near it in circumstances in which it was not only us that was identifying the relevant figures to the court, but also the claimants. So some of those figures, as to the reach, for example, very large reach of the claimants' tweets, were not even an issue between the parties, and still don't find expression anywhere in the judgment. Can I now, if I may, I hope that's a sort of helpful introduction to the really key aspects. And I've tried to weave in useful related parts of detail rather than coming back to them later. There are things I will have to come back to, but particularly to take the court through what Mr. Fox actually did to say they were baseless and so forth. And I'll come back to that if I may. Could I just invite the court to look at what the pleaded case was? I promise I'm going to deal with the grounds of appeal as they appear in the notice of appeal, but I don't think I can sensibly do it without the court having a real idea of what actually happened at the trial. So if I can take the court to the core bundle, tab 16, at page 194. These are the particulars of claim, and on 198, serious harm is pleaded. 15.1, extremely serious. 15.2, aspects of being particularly reprehensible. 15.3 pariahs, and so forth. 15.4, depublish the tweets of the world at large, published and available on Twitter, including in particular to D's followers, for a period of at least 12 hours. Pausing there, we know that Mr. Blake's one, that he separately and independently published within 3 minutes, was there from October 2020 to the remedies hearing. It was said that the deletion was without an apology or retraction. I'll come to that. Each tweet received a significant number of likes. It's to be inferred in those circumstances the tweets were widely read. So there was a pleaded issue, even just on the particulars of claim, as to extent of publication. And the claimants were positively saying that the court can properly draw an inference from the number of likes. So the claimants inviting the court to that inference, and it was to that that the Annex 2 to our skeleton responded. Then over the page, identifying the number of retweets and likes in each case. So between 2,000 and 2,650 likes in each case, and between 328 and 530 retweets across the piece. And then alleging that the defamatory imputation was subject to widespread publicity in the national television and broadcast media. So just pausing there, what that widespread publicity was and how that narrative settled is entirely a matter first raised by the claimants against Mr. Fox. And can I trespass on the court's patience by just showing you an example of that in bundle 4 at page 22.
Supplementary 4.
Sup 4, yes.
Thank you.
Page 22. You'll see it on this page, and this is actually pleaded by the claimants at para 15.5. When we go back, I'll show the court. This is an interview on the 5th of October, it's the very next day. And if we look at, it starts on page 21, and the passage that I'm inviting the court to look at is immediately in the middle of the page, below the numbers 0321. Well, I think if one's going to throw around a baseless accusation of racism, which, as you say, historically could destroy people's careers, and actually has destroyed people's careers in many ways up and down the country, to throw around these baseless accusations, I think, well, if you're going to do that, then why not? If that's the game, why not throw around some baseless accusations in return? Now, pausing there. When one returns to page 199 in the core bundle, the court will see that they specifically relied on that discussion at paragraph 15.5. Third line down, on Talk Radio on the 5th of October, in a discussion between the D and Julia Hartley-Brewer. So it was just to clarify, it's not just the defendant contending that one has to look at the whole picture. That was the claimant's positive case. specifically relying on an interview where Mr. Fox promptly told everyone who is listening, and would be reported as having said that, as we'd later see, that the allegations were baseless on both sides. The learned judge, we respectfully say, deals with this slightly problematically. I will show the court in the judgment, but she says, well, they can't be equally baseless because one's far more serious than the other. I'll show the court how she dismisses the significance of Mr. Fox saying they're equally baseless.
Are you going to show us your defence to paragraph 15.5?
Absolutely, my lord, yes. So if I can just finish the... would you like to see that quickly, or do you want me to finish the...
Well, I don't mind. It just for the purposes of the note, it sometimes helps.
It's helpful to have them adjacent.
Seeing as you said that both sides have pleaded about it.
Sorry. Page 223, Mr. Callis helpfully tells me.
In the core bundle.
In the core bundle, yeah.
Thank you very much.
Yeah, I've got it highlighted. It's the foot of 223.
Yeah.
And it's paragraph number 55, subparagraph 5. Paragraph 15.5 is admitted, as set out above, the fact that the Twitter dispute between the claimants and the defendants received very wide publicity supports the defendant's case that none of the claimants have suffered any harm to their reputations. To the best of the claimant's knowledge, no mainstream media report of the dispute conveyed the meaning that any of the claimants was a paedophile, or even that any of them was suspected of being so. On the contrary, many of these reports made plain the defendant had not intended to make such an allegation. And, my lord, just in response to Lord Justice Warby's point earlier, there was heavy national press saturation on this story. So the claimant's case was not that it should be confined to Twitter, and nor was the defendant's. And indeed, the real world impact, which falls to be assessed under Section 1, should reflect the reality. And it's absolutely plain that even something that the claimants themselves specifically pleaded at 15.5 goes absolutely the opposite direction. I mean, it's difficult to say. One of the oddities is that Mr. Seymour, for example, complained in his witness statement the allegation was baseless. That was the word he used in his witness statement for the trial. Mr. Fox had said that when he deleted his tweets. He'd said it immediately in the interview that they specifically pleaded in support of an allegation of serious harm. It's unusual for that not really to be confronted properly. My lords, can I just quickly take you back to I'm keeping a vague eye on the time myself, take you back to the pleading, the claimant's pleading, because there are some slightly unusual features of it. We were at page 199. Matters relating to C1, and there was a pleading that there was somebody else with the same name, and the short point on that is that when you searched it, the evidence before the judge was you got two photographs side by side and they're clearly a different person. The learned judge, in relation to that, we say, effectively created it's her judgment at paragraph 89, if I can take the court there. It's in tab 9. It's on page 131 of this same bundle. on the right-hand side, second line of paragraph 89 on page 131, in my judgment, a quick online search would have been a reasonably foreseeable response to these eye-catching allegations, particularly perhaps if the publishee were inclined to scepticism. I accept that once the results came up, and then we get this, a few minutes serious further research would quickly have established that Mr. Blake and Crystal, which is Mr. Seymour, were not their child sex offender namesakes. I mean, what we had in the bundle was, in two different places, was a photograph of what the search returned when you searched for Mr. Blake, for Simon Blake, and there were two completely different looking people, and it was in two places. So this idea of being imperiled by a normal search, but then you have to do what's called serious further research, which the judge finds unlikely to displace that, and there was absolutely no foundation in the evidence for that, I'm afraid.
And while we're in the judgment, what was said about paragraph 15.5 in the pleadings and the response?
Well, that's not addressed.
So not addressed at all?
Sorry. Well, yeah. Well, for the court's note, if you want the note of where the photo is, it's volume 1, page 228. So what normally happens is that the issues in the pleadings are identified, and the court then identifies what the primary facts that are relevant to determine them comprise, and what facts, secondary or tertiary facts, bear on how those issues should be resolved. And then, having found the facts, then identifies what the answer to the pleaded issue is, if necessary, by drawing inferences. But that's not exactly the approach that the learned judge took. Well, can I don't want to pull the court away from something that's caught interest, but if we go back to page 200, paragraph 1510. So the reality on our submission was that there'd been some jolly unpleasant trolling on the night of C1 and C2, first two claimants, Mr. Blake and Mr. Seymour. And the narrative quickly settled in their favour and against Mr. Fox. And by the date of assessment, there was no serious harm at all. And that the actual pleaded allegations had been completely defeated on the evidence at trial. And the two pleaded allegations of 1510 are: C1 felt compelled to tweet that the allegation was untrue and to remove Stonewall and Mental Health First Aid England from his Twitter biography to prevent those organisation from reputational damage by association with a false defamatory allegation against him. Now, C1 saw statements on Twitter by individuals say they would not use services of MHFE because of the association with C1. Well, what we found was the ones where people were criticising Mr. Blake for having used the word twat or been ununderstanding and aggressive to someone who was known to have not necessarily been having the easiest time. But what was wrong with that pleading, as it turned out at trial, was that the inference is that it had all been very difficult and there'd been some real reputational harm. And that's just not true. as a matter of fact. Because what actually happened, and as it turned out, my lords, I actually found this one myself. There was a Stonewall massive support announcement, not disclosed by the claimant, online, siding with him, and I'll show you that in a minute. I mean, and the judge's treatment of that is quite extraordinary, if I may say so. So this is resolving the Stonewall issue. It's taking bits of 1510A, if I may. That's paragraph 87 and 88 in the judgment.
Sorry, which paragraphs?
87 and 88.
Thank you.
Which the court will find on page 131. So at the top of the page, you've got the statement that the fact that both MHFA and England and Stonewall put out supportive statements. And Stonewall's one is the one the judge quotes, but they were both supportive. We're proud to stand in solidarity with our Deputy Chair, Simon Blake, in his case against Laurence Fox. At Stonewall, we believe it's important for white people to challenge racism when we see it and be staunch allies of people of colour. Calling gay men paedophiles is a homophobic slur that has a long, dark history of being used to paint us as threats to children and stop us being treated as equal citizens. Using it to silence a gay man standing up for racial justice just demonstrates how far we have to go before we can say we live in a society where we're all valued and can have and live our lives in safety and dignity. Well, pausing there, they're making the same rhetorical point that Mr. Fox was making. Because they say the allegation was being used to silence a gay man standing up for racial justice. They're expressly stating that. And we say it was completely obvious from the very next morning of the 5th of October that the allegations were baseless. So when this is published on the 6th, the baselessness of the allegation is frankly old news. But the point is that rather than tarnishing Mr. Blake's reputation, Stonewall was incredibly influential. This is before the diversity champions started leaving Stonewall in 2021. Incredibly influential, with a huge reach, and put out absolutely unequivocal message of support. And what the judge does with that, so instead of, yes, the fact that you were concerned about reputational damage of your association with Stonewall is consistent with harm, instead of saying, well, actually, you haven't made that out, because we've seen the opposite, instead of saying that, what she says is at paragraph 88, in these quarters at least, the calumny was clearly not believed. But this statement is nevertheless a direct recognition of harmful impact. The very fact Stonewall thought it necessary and important to offer public support in this way does say something about the probable reputational harm they considered it necessary to counteract. Formal, or indeed informal, statements of support are not naturally occasioned by obviously ludicrous and incredible insults or by rhetorical wordplay. I mean, that is, with the greatest respect, a completely unwarranted stretch to sidestep the fact that the claimant's positive case, pleaded case, was defeated by a document that the Mr. Fox's team had found, which showed they immediately, on the 6th, come out strongly in support, as had MHFA. And equally, the fact that MHFA was concerned not with the paedophile allegation, but with Mr. Blake using the word twat, only came out when we finally got disclosure of the letter, the MHFA letter that I mentioned to the court already this morning.
So does the judge make any finding at the pleaded allegation at 1510A last line, the last sentence?
No, there's no finding that.
Right.
So
And was there any evidence of those? What did the first claimant say about that?
Well, we put to Mr. Blake, who...
Well, yeah, what did he say about it in his witness statement?
Oh, in his witness statement.
Because if you're saying the judge overlooked an uncontroverted fact, then we just need to chase it all the leads down.
Well, on this one, the point is this C1, the last sentence,
Yeah.
was an averment by him, and what we identified were the Lord Patel and MHFA ones.
I've got that. What did he say in his witness statement about it?
I will check that, my lord, to see if there's anything different. But that one of the features of the case was that a lot of the primary documents that you might have expected to get early on either didn't come early on, or when they came had no metadata and you couldn't see when they'd been sent. So there was an element of probing in the dark under some considerable pressure to understand exactly how the case was being put. Then B, 1510B, still on page 200.
Yep.
C1 has also felt compelled to disclose the circumstances of D's allegation against him when applying for new trusteeship positions. Felt unable to apply for one. And the big one that he was applying for was an NHS trust in a DEI board position on an NHS trust. Very, very senior role. And the answer is, did he get the position? Yes, he did. So if the judge is trying to identify whether his DEI credentials were harmed or burnished, it's either neutral or burnished. But you cannot infer serious harm from the matter that was raised in that way. Because there are two reasons for that. First of all, it is inconceivable that the NHS Trust would have employed someone if they had a scintilla of a suspicion that the person might be a paedophile. They just wouldn't have done it. And one of the things that the learned judge did not do, which we respectfully say she should have done, is to make all the proper findings of fact about what actually happened, particularly where they arise on pleaded allegations. Look at those, and then against the in the face of what you might expect from her single meaning theory, say, does this tally? Because the striking feature of this is, even as a matter of basic logic, the theory of the judgment doesn't work. Because the structure of the judgment is basically to set up the unbelievable gravity, quite rightly, in the single meaning, persistence, and so forth. All of those things. If correct, and that had been anything like the real-world impact, how does that fit with Mr. Blake getting the job as a DEI board member at an NHS trust? Never asked, never answered. And it's a totemic example of why drawing inferences is not a substitute for finding the primary facts. It's also a totemic example of how, before embarking on the inferential exercise, finding the primary facts does what the learned judge refers to as the inferential groundwork. So for both those reasons, it is very unsatisfactory that was not resolved. Your Lordship asked him about the claimant's witness statement, and that is in SUP Volume 1, and what he said about it. and page 12 and page 14 are the two parts. Page 12, para 29.
Sorry, can you give me the bundle again? I was
I'm so sorry. It's bundle 1,
Bundle 1.
sup 1, page 12. Tab 1 if one's in hard copy. I think the lady might be in hard copy, I'm not sure.
I am, thank you.
He recognises in 29 an expression of regret for the unnecessary language. That's MHFA. And then 37 to 39. He says, it's really in 39, he says, during the interview stages for my roles with the Support After Suicide Partnership and Sussex NHS Foundation Trust, I was asked whether there's anything involving me that could bring the bodies into disrepute. I considered I should make full disclosure of the fact that an allegation was made against me. There it is. So,
whilst just dealing with your case on inference and all the rest of it, did the judge make any findings about the pleaded or the evidence about the tweets and the responses at paragraph 26 in terms of the same witness?
No. Well, I'm trying to give examples, sort of. It's more than the tip of the iceberg, but it's far from a complete. I can just give an example of what I haven't said on MHFA.
Yep.
There was an entire section of cross-examination delving into how it was that Mr. Blake had been able to agree a statement with MHFA, and exactly when all that happened and the difficulties with his evidence on that. Not even touched on. So this was not a small point. A, it was pleaded. I'm just saying, live at the hearing. And I mean, if I can just say this on behalf of my client, Mr. Fox, he did sit through the whole thing and watched what happened. And that did inform his reaction when he received the judgment. Because he'd seen the evidence be tested in front of a judge. And when the judgment came with large and important things completely missing from it, I think he would accept that he was angry about it. My lords, can I just mention an important point if you still got the witness statement open?
Yep.
So on page 12, does your lordship see paragraph 26?
Yep.
So I saw Mr. Fox's tweet first and then saw the responses, which followed quickly. Seemed to me responses kept on coming. Did not know at that time that I could turn off notifications on Twitter. I received homophobic abuse after and as a result, including these. And those examples, my lord, turned out ultimately to be responses to the Here We Go tweet, which was Mr. Blake's own one, which got 594,000 impressions. It's about 3 times, 2.5 times what Mr. Fox has got. And we didn't even know that existed, and putting it pretty neutrally, it was, how can I say it, not apparent from the pleading, putting it that way, because alleged tweets were admitted to have been sent without any mention of the Here We Go tweet. And I can explain, if I may, it's slightly tortuous.
So can I just so what's your case that the Here We Go shouldn't have been tweeted, or?
Well, our case, just a matter of basic defamation law,
Yeah.
Just as the judge found against Mr. Fox that things that he republished, he couldn't complain about.
Yeah.
Similarly, republication by the claimants and harm done by that is not something they can claim for.
So
And
this is all republication, you say?
it turned out, well, there are 2 points. One is it was republication by Mr. Blake, to which they were responding. And 2, the "Here we go" tweet was not disclosed to us. We tracked it down when, slightly unusually, if I may say so, there were particulars added to the pleading of serious harm in reply. So things that should have really, by amendment, been in the particulars of claim, if we go to core bundle 244,
244. Thank you. Paragraph 16.
yes.
Yeah.
So we get, well, at the bottom of 16.2, sorry, we better read the whole thing. 16.2, following and because of D's tweets about C's, each C is the subject of tweets repeating the allegation that they were a paedophile and that C2 and C1 and C2 experienced homophobic abuse. Many of the tweets cannot be recovered because the accounts have been suspended or deleted. Therefore, the full extent of their publication cannot be ascertained. While the Twitter republication of abuse in relation to each C will be the subject of evidence in due course, examples in relation to each C are given below. Now, pausing there, this was a pleading of their primary case that should have been in the particulars of claim. It was a pleading by example, which I think my learned friend, my Lord Justice Warby has deprecated in another case in Judges of Sussex. And it then lists all of these. And what we did was we tried to find where these had come from. And when we did, we found that they, apart from I think 3 or 4, which were actually, some of which were in pretty neutral terms of themselves, but mostly they'd all come from the republication tweet by Mr. Blake. And in a sense, just sort of stepping back, it's not really surprising, because if Mr. Fox's paedophile tweet about Mr. Blake gets 200,000 impressions, and Mr. Blake's tweet of a picture of that gets 594,000 impressions, you're going to expect about a 3-to-1 ratio of recipients. But the short point is that Here We Go was just not disclosed to us. We didn't even know it existed. And the admission of the tweets that we had identified as having been tweeted left unsaid that there was a very important, potentially confounding tweet that Mr. Blake had tweeted. So that was extremely unsatisfactory. We were originally provided these with no dates on them. So that's why we had to go and try to Google and search Twitter to try and identify where they'd all come from. As an example of the Here We Go tweet, just so that the court knows this was heavily fought over in the at the trial before the learned judge. in our closing submissions, in our trial skeleton, our closing submissions, in our oral submissions, and in cross-examination. And other than reciting the existence of the "here we go" tweet, the judge does not engage with that issue at all. My lords, could I take the court, my lord, my lady, to page 213 in the call bundle? Sorry, call in the call bundle.
213.
Call page 213, and my lady, it's tab 17, I think.
Yep. Paragraph 30.
Exactly. Yes. Just taking in stages.
And that's paragraph 30 of.
This is our amended defence and counterclaim.
Thank you.
Now, the court will see there, at paragraph 30, when readers came across the first responsive tweet as a result of it being embedded in the "here we go" tweet, that's the paedophile tweet about Mr. Blake, they would have understood that the first claimant wanted to publicise the first responsive tweet to inform his followers as to the direction in which the defendant had taken the debate. They would have understood that he did not take the use of the word paedophile by the defendant literally or seriously and did not expect anyone else to. Pleaded issue on that tweet. If you go to the previous page, so that was really addressing impact, feeding into what inference should be drawn about impact or what conclusion should be reached about it. 4, which is, it's paragraph 29, which begins on the previous page, sub-paragraph 4 at the bottom of that page, page 212. 4th, very substantial number of people would have seen and did see the first responsive tweet as a result of the first claimant having retweeted it himself, together with the comment, "Here we go," at 17:32 on 4th of October 2020, 3 minutes after the defendant posted the first responsive tweet. The "Here we go" tweet has never been taken down. To date, it's received 594,000 impressions, 283,000 engagements. And that is a very high number of engagements for the number of impressions, because I think Lord Justice Warby's observed in another case that impressions don't necessarily mean has actually read it or taken any notice of it. But when you've got that level of engagement, it's striking. Retweeted 282 times, liked 2,640 times. It's likely that a very large number, and quite possibly the majority of people who've read the first responsive tweet have read it as a result of the first claimant having retweeted it to his followers. So this is, first there's the republication issue, then there's and what did everyone take from this being part of the discussion from 3 minutes after the original tweet. And in my note, I'm going to not take the court to all of the references in our skeleton and closing where we addressed it. But I hope you can take it on trust that we did. And the learned judge was kind enough to say that Mr. Fox's team had undertaken a meticulous and detailed exercise analysing the pleadings and the evidence. And with respect, we are grateful for that observation, and it's correct. What we don't find is the learned judge dealing with that analysis on multiple issues. in relation, just while we're still in the pleading, page 217 is the final point. And it's para 44.1 and paras 29.4 and 30 I've just shown the court were repeated again. So the "here we go" tweet was not only the majority, a much bigger publication, and within 3 minutes of the original tweet by Mr. Fox, but it was also the source of most of what was pleaded as abuse, which was what the case boiled down to. As we explain in our skeleton argument, our case of the learned judge was that the abuse was doubtless upsetting, but overall, within probably a matter of a week or so, there'd been absolutely no harm to their reputation whatsoever, certainly not any serious harm, and by the date of assessment, that was unanswerable. And all they had was the complaints about some upsetting trolling on the night and then a couple of days thereafter.
And do you say that doesn't amount to serious harm as a matter of law?
Well, on the facts, it didn't. I can't say that you could never have a situation where that could not be evidence of serious harm to reputation. But in this case, we had all of the confounding factors, which the learned judge also didn't deal with. So language is powerful, with an estimated 1.1 million impressions on the same evening. I mean, the judge just says at a high level, well, Mr. Fox basically walked it back a bit, but not totally, and it wasn't a prompt and prominent apology. But she doesn't confront each of the examples of the confounding tweets and statements by Mr. Fox, identify their reach, because she doesn't deal with reach of anything, and consider the sort of question that my Lord Justice Warby put to me about overlap and the. But the irony is, the claimant's positive case was this suddenly became a massive news story in the national media, and the first thing they relied on was Mr. Fox going on the radio saying the allegation was baseless. So even if we were in a situation, my Lord Justice Dingemans put to me, is it a matter of law, is it incapable? I think the answer's got to be no, because you could have facts where it obviously was capable. But on these facts, it's absolutely impossible, particularly when the claimants themselves plead that it became a national news story, and they plead the very interview in which Mr. Fox said the allegations were baseless, as well as obviously language powerful the night before, deleting the tweet as he was requested to do, and when he deleted it, tweeting to the same effect, which I can just show. The reference gone out of my head for a second. Sorry? Yep. It's the first Daily Mail article. I think it's tab 46. And I'll give the court the page.
Sorry, tab 47.
Sorry, tab 47. And this is the first daily. I'll just show you 240, if I may.
Of what?
Of bundle S1.
Thank you.
So 240, this is the first Daily Mail article. And you can see it's the 9:25 in the morning on the 5th of October 2020. And that's why we know that Mr. Fox had deleted his post before that time. So that was the evidential pin. I mean, it might have been earlier. He can't remember exactly when it was. It might have been considerably earlier that morning. But we know that by 9:25 in the morning he deleted it. And if we go to page 249, the very first article, 249, and they took a screenshot for the purpose of their article. So we've got it there. If the game nowadays is to throw baseless insults and accusations about, then we should all be free to participate. Making it absolutely clear. Having said that, I've deleted the tweets posted yesterday in response to being repeatedly and continuously falsely smeared as a racist, as they just serve as a distraction to the important work that needs to be done. And there are lots of other articles in the bundle, my lords. You know, language is powerful tweet got plenty of press. Examples at page 286. I won't take the court through it, but we agree with the claimant's pleaded case that it became a national news story, as it obviously did, plain on the face of the documents. And he identified the allegations as baseless before 9:35 the next morning. On Twitter. And I wonder if there's any chance I could get a little bit more water. Sorry. It's just out of reach. Thank you very much. So he identified them as baseless before 9:35 the next morning. Thank you so much. And then he did the interview on the same day, the 5th, with Julia Hartley-Brewer, which was pleaded by the claimants, 15.5. As how the story had caused harm. And in that interview, he expressly said they were baseless. And with great respect to the learned judge, it's not good enough just to sidestep those things by saying, well, the allegations aren't equivalent. The relevant paragraph of the learned judge's judgment is paragraph 91, which is at page 131. In tab 9, my lady. So she starts at 90, except that Mr. Fox took a number of steps to limit the impact of his allegations. So she recognises the existence of the steps. There are just no actual factual findings about reach, consequence, audience, scale of publication, sequencing, effect when read together, etc. And she says the tweets of 4th, 5th and 13th of October contain a degree of stepping back, or at least dialing down. Well, we respectfully say, if you go and say that what you said yesterday is baseless, it's not a degree. I'm sorry. With the greatest respect, that's not a fair or even an available characterisation. They do not, in my view, merit the description of prompt and prominent apology Well, I think that was borrowed from one of the authorities. I think it's Cook. It's Cook at paragraph 43. But this was not a case where an apology per se, although Mr. Fox did also apologise as well. This is not a case where the apology per se was being prayed in aid. We were just simply addressing what did the publication of the statement in fact cause serious harm under Section 1 of the Defamation Act. It's a perfectly straightforward factual question. And the answer was no. And you can't set up a straw man of a prompt and prominent apology, say we haven't established that that's what it was. I mean, we don't accept that's right, but anyway, do that, and then sidestep it and leave the spectre of serious harm to roam around the rest of the case unchecked by the actual facts. So what the judge says, she after not a prompt and prominent apology at 90, says they do not withdraw the allegations or make unambiguous clarification of their complete baselessness in any terms approaching the wholly unqualified nature of the original imputation. But what she's talking about in the original imputation is the single meaning, because that's the driver of the inference that she later draws. So she's also missed out the step of considering that one, probably on Twitter anyway, for much of the audience, the three tweets to the three claimants would have been associated with each other. They were all involving Mr. Fox. But as soon as it got into the national news, they were all reported together. And one of them was obvious mimicry, as the Court of Appeal has found. So you can't carry on with a single meaning, which is a legal fiction, an understandable one, but a legal concept, I should say. You can't carry on with a legal concept when the question the court's asked to decide is a factual one. So we respectfully say that was an error of approach, as well as informing why perhaps not as many facts were actually dealt with as possibly should have been. So what we would have said was one of a number of complete answers is rejected in those paragraphs which we respectfully contend A, don't do the work to identify what actually happened, for all the reasons I've submitted, and B, reject them on a basis that isn't available. And there's a sub-point to B, because the court is not concerned with outlier crazy people. The court is concerned with harm to reputation and whether that reached the threshold of seriousness. So there's also a qualitative assessment that you are simply unable to do if you don't properly find all the facts. There's another curious factual feature in the judgment, if I can take the court to it. Still in tab 9 in the same liability judgment, the extent of publication is dealt with at paragraphs 69 to 73 on page 126. Tab 9, 126, paragraph 69. What is, with the greatest of respect, somewhat extraordinary, is that the learned judge headlines everything done by Mr. Fox to contribute to the scale of publication, and totally omits the terms in which the claimants criticised him for his Sainsbury's tweet and the enormous reach of those tweets. So there is a word, and it's the word response in line 4, and that's the bit that refers to what the claimants did in this story. And as the court will appreciate, we made some fairly fulsome and robust submissions about what claimants had done. So that little word response is the only reference to anything done by the claimants on extent of publication. So what she says is, I consider the evidence of extent of publication. So pausing there, in this section, obviously I've made the submission already, but none of the figures are addressed. There's no relative understanding of what happened. I'm entirely satisfied this is a mass publication case in the light of the following circumstances. Mr. Fox's allegations were of inherently eye-catching, not to say startling nature. They were also made in the context of the response to his attention-grabbing call to boycott Sainsbury's. That in turn was made in the context of Mr. Fox's series of high-profile and outspoken challenges, the ways in which he thought cultural orthodoxy was suppressing free speech about racism, which had themselves provided regular national talking points ever since the Question Time affair. B, the soft launch previous week of the Reclaim Party with manifesto to similar effect. All of that made them inherently likely to reach a mass audience. And everything that goes on, all the way up to 73, is all about Mr. Fox. And similarly, when you get to Mr. Fox's case, he's also to blame for what was said about him there as well. In the extent of publication section that deals with that. And in circumstances in which the available figures confounded the impression that the learned judge had, it was unfortunate she didn't refer to them. Can I take the court, if I may, to our to bundle S4.
Yeah, page.
And our tab 10, page 223.
Written closing submissions.
Our defendant's written closing submissions.
Thank you.
And over the page 224, the court will see there are 2 pages of the index of to those submissions. And if we go, for example, to page 267, 267 is other confounding tweets on Twitter, and this is all part of a long section on confounding tweets under the heading within the section on seriousness of imputation, which starts at 261, and we dealt with that in quite a lot of detail, and we even cited Cook at 114.1 on page 269, eradicating or minimising the unfavourable impression. So we did try to assist the learned judge in drawing to her attention this and quite a lot else. As the court will see, they were very carefully indexed and hopefully carefully laid out and helpful, and were 113 pages long. And I think that's part of the meticulous analysis of pleadings and evidence that the judge was referring to in her judgment. Behind our skeleton argument, which is found at page 60 in tab 4,
Sorry, 60 of...
same bundle, my lord,
Yeah.
S4, tab 60, it's tab 4 in
Okay.
hard copy. We did in opening, hopefully a careful and helpful job running to 74 pages, where we sought to analyse exactly how it was being put.
Sorry, page?
It goes up to page 133.
Thank you. Yeah, although the 74-page skeleton arguments are rarely helpful.
Well,
Anyway, it doesn't matter.
Understood, my lord. We did actually consider trying to do something less. The problem was, if you look at page 61,
Yep.
we thought it necessary in this case to do a very careful identification of what had happened in fact. There were 3 claims and 3 counterclaims. We also addressed the defences and remedies, because this was the opening for liability and remedies. So I hope your Lordship will forgive the normal aim of 25 pages, which we got close to in our skeleton for this court. Wasn't quite achieved, but
So
we
which is the bit of this skeleton that you're particularly drawing our attention to
Well, I was
for this purpose?
I'll come. I've got some references by theme, which may be useful later. But what I actually wanted to take the court to was Annex 2, which is at tab 6, page 140. And this was an annex entirely devoted to the scale of publication, and an enormous amount of work was done in adding things up, as I think Mr. Callis calls it, and setting them out. There's a spreadsheet on page 142 showing the tweets. So the top in blue on page 142 is Mr. Fox's original boycott Sainsbury's tweet, and because it was deleted, we don't have the impressions number. But and Mr. Callis can explain it if it helps. But there's a very careful, sensible and cross-checked way of estimating, which is explained within this annex later on. And that's how we worked out, roughly, what order of magnitude the scale of publication was, because it was obviously relevant. But you can see the first red one is the Nicola Thorpe tweet, in red, any company giving future employment to Laurence Fox does so knowing, and there's the unquestionably denially publicly a racist. That got 766,000 impressions. And then, what a mess, what a racist twat is Mr. Blake. C1 gets 739,000 impressions. Huge numbers.
Sorry, where are the impressions?
On the right-hand side, my lord, on page 142,
Yeah.
there's an impressions column.
Oh, yeah. Sorry,
At the top.
right at the end. Yeah.
Yeah, right at the end.
Sorry, I missed that.
Yeah, and so your lordship will see that the blue squares under
Yeah.
that are empty, where we don't have, where the tweets were deleted. We haven't got the impressions. Either they were deleted at the time or over time had been deleted. So huge number from Nicola Thorpe, 766,000. And bear in mind that the learned judge in her judgment says, well, I don't think this is, the reach by the claimants wasn't really because she was a former actor. And the judge sidesteps the fact that she's not only a former actor, she's a current celebrity, and she was on Coronation Street, and she became famous for standing up against a requirement to wear high heels as a receptionist, which she took to Parliament. So she had impeccable DEI credentials in the public mind, and was a celebrity, and was attacking Mr. Fox in very intemperate and aggressive terms. 766,000 impressions. Mr. Blake, 739,000. Mr. Seymour, 451,000. And then when you go down to Mr. Blake, you can see the blue ones are at the bottom of the page are the paedophile tweets. And we estimate those between about 160,000 and about 240,000. I can identify the exact figures in a minute. You can see Mr. Blake's Here We Go, 3 minutes after, is absolutely massive, 594,000. And then, if we go to over the page to 143, towards the bottom of the page, about 3/4 of the way down, there's a green and a yellow bar going across. Those are the two. Those are the two tweets by C1 and C2 that they are announcing that they're suing Mr. Fox, and they get 2 million impressions each. Sorry. Yeah. Yes. So that's obviously much later in April. When they actually do issue. And on that, the internal WhatsApp messages, which we eventually got by the order of Mr. Justice Nicklin shortly before trial, and because we were so pressed, we only got 48 hours worth, include things referring to how excellent it is to have this battle with Mr. Fox when he's trying to set up his reclaim party. And in the event, the proceedings are issued on the eve of the launch. There or abouts. On the eve or thereabouts of the launch of the Reclaim Party. If we go over the page to 144, there's an explanation. I'm not going to take the court into all the detail of it, but an explanation of the impressions data for the party's tweets, what Twitter analytics were available, 12 to 14, the methodology for estimating impressions, and this had been done against the background of A, having served a hearsay notice about how Twitter had changed and now worked, and introduced that material with a proper foundation. B, having agreed a statement about it with the claimants. And then this was the analysis of the disclosed data and what inferences we said could properly be drawn from the figures as to reach. And applying the methodology at 146, seven tweets by D, we're seeking to estimate impressions from the known engagements. Estimated scale of publication, 7.5 million impressions, boycott Sainsbury's. So what the judge doesn't engage with is the fact that when the claimants attack Mr. Fox, and he responds to them, he is responding to tweets which on their own got very large numbers of impressions themselves. And then 147, tweets sued upon by C1, an estimated 240,000 impressions. On C1's analysis of how many retweets there were, there's a difference between subparagraph 1 and 2 is that C1 pleads 530 retweets, D only admits 401 retweets. So there are two, it's one estimate's 240,000, the other's 190,000. The point is it's about a third of Mr. Blake's own retweet, the here we go tweet. Tweets sued upon by C2, estimated 220,000. And then obviously C3 was struck out by the Court of Appeal, but that was 162,000. And then language is powerful, just so we've got the context. So I was making a complaint the judge ignored the scale of other publications. I'm trying to make it good. Is paragraph E, estimate 1.1 million. First apology tweet, 160,000. Tweet about his acting agent leaving him because of racism, got 4.5 to 5.5 million impressions.
Sorry to interrupt. I mean, just on the judge's finding that it was a mass publication case, do you say in the light of those figures that the judge wasn't entitled to make that finding?
My lord, we don't say that. But what we do say is that's not an answer to all the relevant questions.
You say it has to be followed up with the other material.
Well, mass publication of what?
Well, and one possible answer, if Mr. Fox published in round terms 250,000 times, which is roughly where the judge is, the question is whether that caused serious reputational harm, and it doesn't matter whether the claimants also caused themselves some harm or didn't cause themselves some harm by republishing it and saying it was a load of rubbish.
Exactly.
If they did all that to a load of different people, this is my point about overlap.
Yeah, but your lordship's absolutely right. But I mean, there are three facets. I mean, first, it's completely correct that if you tweet to 250,000 group of people, and in fact, that publication of that statement occasions serious harm, that's the end of it.
Yeah.
The anterior question is, what harm was actually caused? If one assumes serious harm has been caused, that's different. Our complaint is that analysing the extent to which the harm that was being complained of I mean, it's totally astonishing where someone complains of abuse and lists in their reply a whole of, and it turns out that that's from a non-disclosed tweet of their own.
I see that. That's obviously right, but
Yeah.
is this perhaps doing the same thing that I think you complain of the other way round, of saying, well, here's a lot of specific complaints, and I can knock all those down, and I did knock them all down at trial as not being the consequence of what I did. But that doesn't defeat the case that the consequence of what Mr. Fox did
Yes, but
still cause serious harm.
but the
Knock
difficult,
down the specifics, but you don't thereby deal with the whole of the general.
there are several responses to that, my lord, which I'm sure is by your lordship's asking the question. The first is that the learned judge didn't draw any distinction at all between the sources of harm and didn't deal with the "here we go" tweet at all in the liability judgment. So your lordship's premise was not tested or considered by the judge. There was no analysis of scale of publication, overlap, prominence, no factual analysis of anything. And you get instead a sort of overview that's adverse to Mr. Fox. And that becomes really important when you're dealing with the confounding tweets and the confounding matters which aren't engaged with either. I mean, it's got to be quite an unusual case where the person intimates pretty clearly baselessness within an hour, expressly states baselessness the next morning in the deletion tweet, whilst removing the tweets at the request of the first claimant, and then immediately goes on a talk radio show because it's become a national news story that the claimants rely on as epitomising the source of harm, in which he declares them to be baseless. I mean, all I'm saying is, well, I agree that without all of those things, your lordship's statement is self-evidently correct. But we're with those things. And we put quite a lot of effort into the trial to challenge the evidence, work out what actually had happened, which the judge remarks upon that we did, meticulously. And it's against that background that the judge, we expect to say, hasn't actually dealt with those points.
Sorry, can you just give us a reference to where the judge remarked on it? I have read it.
I think it might be 68. I've got it somewhere. It's that's one. Subjective.
63. Is this the word meticulous? Is that what we're looking for?
Yeah.
Yeah. It's 63. bottom of
63
page
mounted
124.
root and branch attack on the claimant's case
Yeah.
and serious harm. He and Mr. Fox's wider legal team took a meticulous and comprehensive approach to analysing the detail of the relevant pleadings and evidence on this issue. And I've considered each point in the overall critique full with care. But there isn't actually any evidence of that in the judgment. And that's the complaint.
And then she says it's of course neither necessary nor desirable for me to make detailed findings of fact on each and every point raised,
Well, that's...
required in the end to take an overall evaluative view.
Yeah. I mean, everyone accepts you don't have to make a finding on every point.
No.
I mean, all the law's absolutely clear on this. There's no real scope for debate about it. My lords, would it be convenient for me, for us to rise slightly early, and then I can slightly take stock, because I've got quite a bit to get done. Learned friend Mr. Callis is on lead guitar on one of the issues of law, which is ground 4, briefly, and I'm still aiming to be done by 3 as promised.
Well, I mean,
Would that be convenient?
I mean, you can certainly stop, but it's in your own time, as it were, rather than miss pages.
Oh, no. I've simply is if it were possible to take lunch and adjournment from 10 to 1 to 10 to 2, rather than from 1 till 2. But if not, I can.
No, none of us got meetings, so we can rise now, and then we'll be back at 10 to 2.
I'm most grateful.
Can I just check, because is that right? Okay.
I'm most grateful.
10 to 2. Thank you very much.
All right.